Hello, my name is Narissa Ferry and I am one of the Medico-legal advisors at MDA National. As we move into another year of the COVID pandemic, it's a good opportunity for us to reflect on the challenges facing our doctor members, and in particular our very busy radiologists. As a member-owned organisation, it's really important for us to engage with you in a way that adds value to your practice. And while we would prefer to see you face-to-face, another year of COVID has sadly sent us back to our screens. It is with great pleasure that I present a year in review on behalf of the entire professional services team. On the regulatory front, we've seen changes in the way that AHPRA conducts its investigations in an effort to deal with notifications in a more efficient manner. AHPRA will now call practitioners for a telephone discussion while a notification is in the triage or assessment stage. This is likely to be the first time you'll become aware of the notification. While the intention is to streamline the process for low-level matters, this step is voluntary and practitioners should remain cautious about the extent to which they provide a verbal response. We recommend you seek advice from MDA National before speaking to AHPRA, as file notes of these conversations will be retained and can be relied upon as evidence in an investigation. We have also seen an increase in the number of practitioners being compelled to attend interviews under Schedule 5 of the national law. Schedule 5 interviews are requested for matters that are already under investigation, so it's not a power that AHPRA will use at the beginning of the notification process. The interviews can be lengthy and confronting for practitioners as they're often put on the spot and don't have an opportunity to seek legal advice before answering questions. The questions can be open-ended, which can lead to practitioners saying more than they need to and potentially making them vulnerable for further investigation. In the past, AHPRA rarely compelled interviews under Schedule 5, preferring practitioners to respond in writing, which allowed time to obtain considered legal advice and ensured that practitioners had a proper opportunity to consult their notes, reflect on their response, and to undertake any education. Unfortunately, the legislation leaves little room for practitioners to be excused from attending these interviews, so we encourage you to seek advice from MDA before participating in a Schedule 5 interview. Other changes include the establishment of triage committees to assist in expediting matters before the board. Triage committees are delegates of the medical board and convene on a more regular basis than other delegates. AHPRA also has a dedicated COVID-19 team to respond to concerns relating to the pandemic. This team deals with notifications about practitioners issuing vaccination or mask exemptions against ATAGI and other government guidelines, doctors who are critical of the public health response to the pandemic, and other related complaints. This team tends to act quickly and seeks an explanation of any reported conduct or performance, with the goal of ensuring that health practitioners are supporting public health efforts. The national boards have published guidelines regarding the expectations on registered health practitioners, and we encourage you to visit the AHPRA website if you'd like more information. According to the annual report for the Medical Board of Australia for 2021, 5,516 notifications were lodged with AHPRA, which represented 5.7% of the profession. The most common types of complaints related to clinical care, communication and medication. No further action was taken in relation to 71% of notifications, conditions were imposed in 6% of notifications, and 0.4% had their registration suspended, cancelled or surrendered. The Medico-legal team has noticed a gradual increase in the number of queries received via email, online notifications and live chat. Unsurprisingly, given the sensitive and often complex nature of medico-legal queries, phone is still by far the most common means of contact for our members, regardless of age or stage of career. In the past 12 months, we've received around 12,000 new notifications, with around 20% of those triggering the policy. Despite the pandemic, it has largely been business as usual in terms of queries, claims and investigations. If anything, COVID has just added an extra layer of complexity for everyone involved. We've seen COVID queries vary between the states and territories as public health orders and mandates have been amended and borders have gradually come down. In addition to providing personalised and tailored advice to individual members and practices, we've regularly updated our dedicated COVID webpage for ease of access. We certainly don't underestimate the additional pressure the pandemic has placed on doctors and their practice staff, both personally and professionally. Keep an eye out for our upcoming winter edition of Defence Update, which includes a pull-out feature on managing challenging patient interactions during COVID-19. Other common medico-legal themes are perennial issues such as privacy and confidentiality, the release of patient notes, family disputes and deceased estates, requests for medico-legal reports, employment queries, subpoenas to give evidence, and ending the doctor-patient relationship. The most common claims against radiologists relate to diagnosis, with the most frequent issues being perception and interpretation errors, a failure to convey meaning, a failure to report an incidental finding, and poor communication. 1 in 3 claims became medical board matters, and 1 in 4 were referred to the Ombudsman or Health Services Complaints entity. Procedural complications include infection and pain resulting from joint injections and nerve root sleeve injections. Diagnostic errors are often the result of cognitive bias, insufficient or misleading records, and failure to appreciate interval growth of a lesion. While some aspects are simply human error, practitioners can mitigate potential problems by avoiding fatigue, reducing distractions, and having an effective work environment. Another emerging issue is inappropriate billing under Medicare. As a member of the MDA National Medicare Committee, I manage a number of high-value investigations conducted by the Professional Services Review, or PSR. Other than some targeted compliance around specific item numbers, radiologists appear to largely escape scrutiny when it came to Medicare audits and investigations. And this may have been the result of difficulties around figurehead billing, but this is certainly no longer the case. Individual radiologists are being investigated, even though a large portion of their billings relate to reporting by other radiologists within the group. Each doctor is responsible for their own provider number, and you should know what is being billed to it. While figurehead billing certainly has its place in radiology, the director of the PSR has made it abundantly clear that an item 104 is a professional attendance and therefore cannot be figurehead billed. In addition, an item 104 can only be claimed if you meet all the criteria under the MBS, including a referral which requests a professional attendance or opinion. It cannot be billed for explaining the procedure and/or providing post-procedure advice, as this is already included in the diagnostic or procedural item. If you bill an item 104, your note should clearly reflect the criteria contained in the item descriptor. On the subject of medical records, maintaining contemporaneous, detailed and legible notes allows for continuity of patient care, and it may be your best defence in the event of a claim. Informed consent from the patient is also crucial, and this must be obtained and documented appropriately. One of the most notable radiology cases in recent times is the coronial inquest into the tragic death of Peter Hickey. The patient was a 43-year-old mum and business executive who was invited by her employer to undergo a cardiac health assessment in March 2019. The cardiac health assessment consisted of a coronary artery calcium score and a CT coronary angiogram. The patient, who had no prior cardiac history, suffered a severe allergic reaction when the contrast was administered intravenously. Resuscitation was commenced and an ambulance called, but the patient sadly died in hospital about a week later without regaining consciousness. An inquest into Ms. Hickey's death found that the impetus for the cardiac health assessment program had arisen from the employer's best intentions after a co-worker suffered but survived a cardiac arrest. The inquest examined issues of informed consent, and concerns were raised about the way the program had been set up, favouring profit over patient care. The referring doctor and the radiologist were both reported to AHPRA, and the coroner made extensive recommendations relating to improving the recognition and management of severe contrast reactions and anaphylaxis. The coroner was critical that the referring doctor had allowed his signature to be used on referrals for patients he had not reviewed, and that he'd failed to apply ethical standards as he considered he held a lesser obligation to persons who he viewed as clients or candidates rather than patients. In relation to the radiologist, the coroner found that the CT scan was performed on the basis of a referral with insufficient clinical detail and that the radiologist had failed to recognise and manage the patient's anaphylaxis appropriately. Radiologists may not be as familiar with the coronial process as some other specialties, so if you find yourself involved in a coronial investigation, we have some excellent podcasts and other resources in our Medico-legal library on our website. But as always, the best thing you can do is contact MDA National for advice. So this brings us to the end of our year in review. We hope to see you in person in the not too distant future, but in the meantime, please feel free to contact Medico-legal Advisory Services or check out what's new on our website. All the best for the remainder of the year, and thank you for trusting us to be your preferred medico-legal provider.